Hey, well, welcome out to our weekly legislative review. I'm Austin Hepworth, and I certainly believe that we can be a part of and contribute to what's taking place in our state. So appreciate you joining to discuss these. If you have bills you would like to discuss, you can let us know. Jill did send a number of them that we can go through. There's quite a few. I think they'll be interesting for people to look at. But if you have a particular one you want to know about, you can raise your hand, meaning press the raise button up top, or you can email or put it in the chat. And then the culture of the discussion that we're trying to promote and encourage is one of seeking understanding. And so there are, I'd say, differing political opinions of people that join these calls and discussions. So don't assume that everyone has your same political opinion. I welcome differing political views and thoughts, because I feel that we can get further and understand more. So we ask for respect and civility with that. But we do have a lot to try and get through in an hour as well. So if you can also limit comments to a short time as we go through some of these, that makes it very helpful for everybody. So to start off, I guess I can here. And let's see, maybe. Hopefully you can see this screen here. And when this is up, I don't see you. So you might have to, I'll check back on the, video stuff occasionally if you have your hand raised or a chat there, but I won't see you immediately probably. So a question was asked. There's a Senate concurrent resolution encouraging practices that promote child independence, and there's kind of a companion bill, SB 75. It's called Family Stabilization Amendments. It's a very unique name because the bill is talking about creating a center at Utah State University to study some things. But the question was raised, should the government be involved in telling us how to parent, or what that looks like? If you look at some of these things that they're proposing that the legislature say, they're talking about levels of anxiety and depression are increasing in children and young adults. Constant supervision thwarts a child's ability to develop important qualities. There's research to suggest that children are safer when unsupervised today than they were in previous generation. Yet such play has declined. Children aren't fragile, they're resilient and capable. It says a lot of these different things that the anxiety and depression, play is crucial, self-directed kids make better learners, a number of these things. And then be it resolved that they want to support children who are of sufficient age and maturity to let them travel to and from school, travel to and from nearby commercial or recreational facilities, engage in outdoor play, remain at home unattended, or engage in similar independent activity. And then they have this program they want them to be able to utilize the Let Grow School program. I think that's a play on words of let go, meaning to take a step back as parents and supervisors. And then they want to look for ways to incorporate childhood independence throughout the core standards for Utah Public Schools. And they want local governments and school districts to enact practices that encourage children to be able to explore, play, wander, and build independence. So on this, and I think it's a good question to say, should the government be involved in these types of things or not? Why are we here at this place? And to answer that question, or I shouldn't say to answer that question of should they be involved, but to say why this has come about this year. I don't have full proof of this, but from my perspective as an attorney, this is coming about because of recent cases across America where parents are getting in trouble for situations where the kids were independent or unsupervised. And there was a mother in somewhere in the South, I'm forgetting the state right now, and her 10-year-old, I think, walked a mile to a friend's house, and a person picked him up or stopped on the street and said, "Hey, what's going on here? This is a horrible thing. Where's your mom?" And the kid said, "I'm just walking to my friend's house." They called the police. The police came and arrested the mom for neglect of their child, because the kid was walking to a friend's house. And the mom admitted that she didn't know that the child had gone to the friend's house, but the child had a phone or something and often went there and called or whatnot. So it wasn't a surprise. But with that type of legal development and the side about one of the reasons why there's more and more supervision of children is because people grow increasingly concerned that if they don't supervise and something happens, they'll get sued. There's this deep fear of a lawsuit coming against parents or supervisors of children. And so my perception on one of the reasons this has come about is because Utah's trying to say we want to be a state where parents don't feel like they have to be helicopter parents, where we have these policies in the law that say, yep, you can have a certain level of unsupervised conduct and play, you're not going to get sued for it type thing. Now, granted, this resolution stops short of saying you won't get sued for it. They're saying it's our policy to promote this type of activity, but that is, I think, where it's coming from. And in response to, they're hesitant to directly say that a parent's not liable for unsupervised play because they're like, maybe there's a situation where they should have supervised. And so if you look at SB 75 in conjunction with this, you see this proposal to create the Center for Healthy and Meaningful Play to be administered by the Emma Eccles Jones College of Education and Human Services at Utah State University. And this is intended to be a center where they focus on the science, practice, and promotion of childhood play that contribute to physical, psychological, social, family, and community well-being. And so this is what the center would be involved in. They do research on it, put out some stuff about it. And then interestingly, they put in that this center will exist for basically 3 years. So it expires in 2028. Now, one of the things to understand when they put these in, sometimes you go, okay, it'll only be around for 3 years. What usually happens is in the session in 2028, there's a bill to extend this and kick this down the road for another 10 years or 15 years or something like that. So almost every session, there's bills that solely exist to change these expiration dates. So the expiration dates are not set in stone, and they often get kicked down the road if people like what's going on there. So curious to know if you have any thoughts on this, whether you think it's wise or unwise for the legislature to jump into this family realm. Okay.
My question is, why is that needed? Why is that center? I mean, I think it's good to let people have some leniency and control over kids that are of a certain age to get around. But why do they feel that this bill is needed? And what is this? What's the financial impact on that? Is it fully paid for by this other company? And I don't know. I just think I talked to someone who was a school teacher, and she said we're supposed to ask the kids as they walk into the room each day what their state of mind is. They have to say, oh, do you feel anxiety? Do you feel helpless? Do you feel angry? Do you feel happy? And one of the choices is ready to learn. And she says out of a class of 33, three kids said they were ready to learn. And I think that this is just becoming ridiculous that people are, I mean, when we were growing up, my dad didn't say, "What's your state of mind today, dear? Are you going to school ready to learn?" It was like, "Hey, buck up, buttercup. You're going to school, and that's what you do, and you go and you learn and you have fun, and it's great." So I just don't know why something like this is needed, if there is a financial impact on it. And I don't believe it's necessary. So that's my position. I'd
So
love to hear
the
other points of view.
yeah, so just real quick on the financial impact, if you click on fiscal note on the bill, it does say that they're proposing 1.2 million to be allocated as an expenditure
Yeah, I think it's ridiculous.
for essentially for 2 years, 2026 and 2027. So decent amount of money. One of the reasons to answer the question of why, and I'm not saying this defends it necessarily, my guess on why they say why is because one of the things that happens with the courts. So if you're in court and you're saying, well, we believe that this is better for kids, the courts say, well, that's great, but what does the science say? And we've moved to a place in society where we demand science on everything. And so I think one of the things that Utah is trying to do is to say, we believe, their statement here says, we believe all these things. We think that kids need more playtime. We think they need more unsupervised time and whatnot, but we need some evidence to back it up. And so I think that they're saying essentially, so we'll create the center, we'll have some students and others work on it, and we will go study it, get some real science behind it, so that we can defend these policies in court. Now,
So
whether that's
the students are, I mean, again, it's like we're trusting students to do this and say, okay, this is, I don't know. Okay,
well, the
I'm done.
students will be a lot of the manpower behind it for sure, but there's professors that oversee it. They're the ones doing the studies, those types of things. So now again, I'm not here defending it, saying it's right or wrong. Just that we are certainly in an environment where you can no longer just say, well, I believe this is good for me. We demand proof. And as a society, we demand that quite a bit. And this is one of the costs of demanding proof, is that people have to research and do things. But on the notion of, one of the concerns I have, obviously, about the government coming in, Utah government coming in and saying, well, I support all these things. I support unsupervised time and all this. I personally feel that's a good thing. I think that kids and parents should have some flexibility and freedom with those things. But I get concerned saying, well, if we allow it to be regulated this way, it's opening the door for states to regulate the other way. And I often get concerned saying, do we want it to be where, oh, I moved to Tennessee or Arkansas or Mississippi and suddenly my whole parenting practice is criminal because states can make you criminal? Or should parents have some more fundamental rights? And I would like to see things like this tied more to is just saying we recognize that parents have fundamental constitutional rights and making a case for that, and pushing this more into making a case for fundamental parental rights across the nation, as opposed to state by state selection on whether you have to be a helicopter parent or not or get sued. And it's a little funny that Utah has this bill, because there is one at the flip side of this that I'll pull up here. Let's see, one of these. It goes, I mean, it's not exactly the opposite of it, but it's a little bit in conflict with it, I think. And this is child actor regulations. You may have seen some stuff about this in the news. And this is essentially saying that there's a lot of parents, or I don't know how many, there's some parents, maybe a lot, who use their kids in their videos, their TikToks, their YouTube, whatever, and their kids are part of it, part of the content, and the parents are making a lot of money off these videos. And this came up as a result of, there were the two moms that were abusing their kids, and but they were putting out that they're these great mommy bloggers or whatnot and different things. They're getting prosecuted, or were prosecuted here in Utah. I think they pled guilty. Ruby and forget the other one's name, but some of the kids testified and said, yeah, we just get used, have to work, we don't get paid, our privacy is taken away, different things. And there's truth to that. For this bill, it's quite long. We won't go through all of it, but it does go through, and it requires that if you're using your kids in content, that you create a trust fund for them. And then the parents can only be part of it if the trust fund's below a certain dollar amount. And once it goes above that certain dollar amount, you have to have an independent trustee you're paying to be a part of that. And I think it was $250,000. And because some of these make quite a bit of money, and they're trying to ensure that there's money for the kids as a result of being part of the content. But one of the things that was interesting, so again, it's one of these things where they say, yeah, let kids do things, play, do all this kind of stuff. But it then comes, and at the end of this bill, it says that once a child is no longer a minor, and it doesn't have a time limit on this, so they could be 50 or 70 or whatnot, they can request that their content be deleted of anything made for them as a child. And the reason I point that out is because that will make it very difficult for any company to do the, and this may get changed, I don't know. But the entertainment industry as a whole, if a kid's in a movie and then they turn 18 and just say, oh, I'd like you to take that movie down now. I don't like it anymore. They get paid to be in it and do these things. And so it's interesting to me to see that that's one of the proposals. And maybe there needs to be a way for kids to object based on the fact that they were forced into it or something like that. I don't know. And maybe this is a whole discussion on the entertainment industry as a whole. But I think that we rely quite extensively in our country on the ability for people to sign an agreement and for their image or likeness to continue to be used. And if you can just pull that back, it's an interesting thing. The other thing it doesn't specifically address that could be an issue here is it does not address high school sports and the fact that we use children as entertainment in high school sports and people pay to go watch those and different things. So I think there's a couple things they didn't fully think through with this bill, but it's one that's there and proposed for this session. Kay, did you have your hand still up or did you have something else to comment on that?
Yeah. Does anybody else in this group agree with me that it just feels like they want to regulate every aspect of our lives? I mean, it's just, we've got, what are they proposing? Like 1,500 bills or something like that, as I've seen this. I mean, there are other laws that pertain to some of these that might be, have this point, but Utah is just turning into this huge nanny state of let's regulate every single aspect of everybody's lives. And I've always wanted to be less government and not more. And this legislative session is unbelievable in the amount of control they want over us. Does anybody else agree with me, or is it just me?
I'm happy to throw out that I've been saying this for a while, but from what I see of both sides of the political spectrum, we are turning to the law to solve our problems. Whether we want parental freedom or we want parental control or whatever it is we want, we ask the law to solve that problem for us. And what's happening, to your point, is the laws come down more and more. And even if I agree in principle even if I agree with the principle behind the law, I get concerned that we're passing a law to state the principle. Because I do believe that law has a place and a purpose. And if we use it to regulate everything and every situation and choose yes or no on everything in every situation, we're setting ourselves up for a state that's no longer liberty. Liberty entails that there's a realm where the law doesn't go. We leave that to individuals. And it's not to say that there's, all law, everything has to have a check and balance on it. Parents have to have some level. Obviously, you can't beat your kids and abuse your kids. The law has to be there to some extent. But I think we often lose sight of the fact that as citizens and as individuals in America, the law is not the savior that can solve every problem and can save us from everything. And when we turn to it for that, it does damage a lot of our society. It makes it so everything's regulated. And then it just makes it so everything's a power struggle of, well, all I have to do is get my person in to then get my preferred laws and rules and whatever. And I go back to law exists for a purpose, but not for everything. So I do get concerned, and I will raise that with some of these things. It's like I say with the Senate concurrent resolution on families. I agree with a lot of the principles, but I don't like the fact that we're turning to law. And I'd prefer just to say, let's just go back to recognizing constitutional protections, that we just have these liberties and we get to decide as parents on these things. That's how I think it shakes out better, and we allow it to morph and adapt as time goes on. But if you have any other comments, feel free to jump in. We'll move forward with this one, behavioral health amendments. This one's interesting to me. It goes a little bit what Kay was talking about with asking kids how they're feeling each day. Obviously, I think there's always some level of balance to say someone could be at a really tough spot, and it's okay to acknowledge feelings at times, but it's also okay to say, times today need to work type thing. But what this bill is doing.
Scroll back? Sorry, can you just scroll back really quick to the top? I'm just trying to take screenshots.
Yep.
Okay.
You're great.
Got it.
SB 48. Yep.
Thank you.
This one has, they say it expands the scopes of practice for mental health therapists, but what it really means is it is making it so you have to have a license to do certain things. And this is kind of the meat of what it's going for. They added, so the practice of mental health therapy in Utah is licensed. You have to have a license to be able to do these things. So they weren't saying that now that you have a license, you can do more things, but they're saying you can no longer do these things without a license is kind of how this bill is actually, what its impact actually means. So you can no longer convey an opinion as to the validity of an individual's established diagnosis without a license. So that means you can't say, yep, that makes sense, or you should get a second opinion on that, because now you'd be practicing mental health therapy. And then it's saying to hold yourself out as having any skills, experience, or training to competently provide any of these services here. And again, some of it kind of makes sense, but what this is addressing is that there's a lot of life coaches out there who aren't licensed, who will talk to people, and they're trying to shut down, and this is very open. They had a news story about this. They're openly trying to shut down all the life coaches that meet with people and talk to them about their mental or emotional health, and trying to force it all to take place under a license. And so I personally have concerns on this. I have respect for professional licensing, but I also know very well that professional licensing also shuts down people's ability to go talk to someone to seek something outside of the established norms. One reason why people go to life coaches is because the licensed profession is telling them one thing and they're seeking for something different. And that's their intentional choice, is that it's not working for them and they want something different. And so these life coaches would be out there and they're trying to make it criminal to now do that, to try and help people if you're not a licensed health therapist. And you can still help in some ways. They'd say we're not totally shutting down help, but they felt it necessary to go after that. So that's one that I look at this though and I go, wow, so I can't even tell a friend, hey, maybe you should get a second opinion on that. That sounds a little wild. And maybe they would say, well, you didn't convey an opinion. But if I said, well, that sounds kind of crazy to me, am I conveying an opinion at that point? I don't know. And I believe we're still in kind of I call it the wild, wild west of mental and emotional health. There's a lot talked about, but I still believe there's very little understood. We don't you know, we like to pretend we know what causes depression or anxiety or all these things, and we certainly understand some of it, but I don't think we've even touched the tip of the iceberg with everything going on or mapping it all out. And so when we try and lock it down so tight and put it behind one license, I get concerned. I know, for example, that, you know, I think about the law and the practice of law, and they want licensed attorneys to be able to give legal advice to people. But in all reality, there's some people that know the law incredibly well. They're not licensed attorneys, but they can educate and comment on it very, very well and very informatively. There's people very good in court. You know, there's some criminals that have been through the system a number of times that know the court procedures incredibly well. And when we make a license, what we're doing is we as a people are transferring personal responsibility and saying, I'm letting the government tell me who's qualified to talk to me or not, and I'm not going to do the research anymore. And so a very common thing that people call me for as an attorney is they hired an attorney that did a really bad job. And they didn't check into the attorney, they didn't look at the attorney, they didn't ask questions because they had a license and they should be good. But licenses allow us to transfer personal responsibility to find these things out for ourselves, to look into people, to check credentials, to, you know, do a little bit of reference check, whatever. But it also forces and gives the government more power to control what can or can't be said or done. And that's where I get concerned, as I say, you know, if you want a law that says I have to disclose to I'm not licensed, sure. But if it's to restrict people and make it criminal to talk to people, to share things that we've experienced, to share things we understand or know or feel we know, I personally get concerned. So I don't love seeing these licensing laws grow like they are. I don't think it helps us out.
This is super concerning for me because I know schools are hiring therapists to kind of groom our children while they're going through changes to, you know, think there may be something that they're not, and super concerning. It's also with Mike McKell as the sponsor. That's concerning.
And Kay, did you have another comment?
Yeah, I just was going to say, and you kind of touched on it, the unintended consequences of this, you know? So by me saying to my neighbor, hey, I don't really think you should get that COVID vaccine, you know, from stuff that I've read or whatever. I mean, I could actually be sued if something like this were to go through because I'm offering my opinion and I'm not licensed and there could be unintended consequences. This is absolutely ridiculous. You know, it's like you said, if you want, I mean, I just wanted to say that this looks like, and you pointed it out, Austin, a lot of unintended consequences here. And, you know, basically the idea is you better be a lawyer because this is all creating all kinds of lawsuits.
Yeah, so one sad thing about every legislative session is certainly just only increases job security for attorneys, right? And I think our country would be better off if we didn't have as much job security as attorneys. But one other thing here with the civil commitment modifications, this is HB 56. This one was, again, I don't have background for this one. Some of them I have background for. But I didn't fully know why all these things were here.
Again, I'm so sorry. I was typing.
This is HB 56.
Okay, thank you.
I get concerned.
Yeah. Senator Weiler's scary.
With the law's ability to forcibly commit people and then forcibly treat people. This one wasn't dealing as much with the grounds to forcibly commit you, but it's dealing more with the discharge side of it. And so it used to be in the law, so the blue parts are getting cut out. And again, this could be, you know, maybe it's not voted for, I don't know, but this is the proposal. The law said when you were discharged from being committed for mental health reasons, they had to provide you with discharge instructions that included a summary of why the individual was committed to the local mental health authority, detailed information about why the individual was being discharged, and then they had to have a safety plan, these different things, and a list of any screening or diagnostic tests conducted during the commitment, a summary of therapeutic treatments provided during the commitment, any laboratory work that was completed. And they're cutting this out. They're saying, we don't have to tell you this stuff anymore as part of just the standard discharge procedures. They do have this thing to say, information about how to request your medical record. And so you would assume, you would hope, I guess, that that's in the medical record. But it's not for sure with this. And so I don't know if hospitals are saying this is too much work for us, it's too burdensome, we want less work. But to me, I get concerned when the law says you can be civilly committed, so meaning you're forced in there. When we let you out, we don't have to tell you why we put you in, as part of the discharge instructions anyways. We don't have to tell you what made us decide to let you go. We don't have to give you, the screening or the diagnostic tests we did, or a summary of the treatments we provided to you. And I just kind of go, I think as individuals, we should have a very strong right to that if we're being civilly committed, we should know those things. So this bill, I'm personally not a big fan of. You can see it a number of times. They go through in the law in different sections and they take out the same information that these discharge instructions have to provide. And so you can see here, each one, there's different situations, and this one has even more things taken out. And so this one even takes out that if an individual's medications were changed, or if they were provided new ones, you don't have to provide that anymore as part of the standard thing. So that was one I felt was worth bringing up. And so that's something. And then to circle back real quick to something Norma said, is one thing that may drive people to consult with life coaches is the cost of meeting with a licensed therapist. I agree. But if you've ever tried to meet with an attorney, they're crazy expensive too. And generally, increasing the scope of licensing laws only further increases the cost of what's going on. Because if all those people no longer can have life coaches to help, and they're now forced into a licensed profession that already doesn't have enough people, the demand goes up and the cost goes up. And so attorneys are super expensive right now because there's a huge demand. And it makes it very difficult for people to afford that. And licensing laws tend to create that type of market restriction. So interesting impact or effect of those as well. Let's see, we'll skip. Let's see, time-wise. Oh, this one, there's just a couple things I wanted to point out in this one. So this is HB 122, National Guard and Military Amendments. Jill had brought this one up. And I always get concerned when it says in the summary that they're exempting it from the Open and Public Meetings Act or the Procurement Code. So if we start going through, we say, where are they getting exempted from the Open and Public Meetings Act? They're changing the appointment stuff a little bit. The governor already appointed the general. And that first part's clarifying some of that. Let's see. But if we go to the exemptions from the Open and Public Meetings Act, this is where I get a little concerned because it follows a number of other trends in Utah. So they say they don't have to have an open and public meeting if the meeting is related to the purchase, exchange, or lease of real property, including of a water right or water share, or is for the discussion of a proposed property development agreement, property development project proposal, or a financing proposal related to the development of land owned by the board. So if we are talking about buying land, developing land, water, using water, these things that are pretty critical to a lot of Utah, it doesn't have to be public. You can do this all you want behind closed doors. And I go, whoa, whoa, whoa. I don't know. I think we should have a lot more light shining on real estate developments, especially in light of watching what's happening downtown with Ryan Smith, with the Jazz, with Delta Center, all these things. He's getting committed to have essentially billions of dollars sent to him from tax funds. And it's presumably to make downtown better, but he still benefits. And at the end of the day, he still owns these things that tax dollars paid for. And there's these redevelopment districts. There's the Port Authority, the inland ports. There's all kinds of things going on with these real estate developments and deals. And I get very concerned when we start to say, let's make those so they don't have to be out in the public eye. I'm a huge fan and proponent of transparency in government. And I believe very strongly they should be very open and transparent things, especially things dealing with our water and our use of water here in the state, if the government's going to use our water. So I don't know if anyone has thoughts on that, but that was one of my big concerns with that bill. Okay, we'll go on to, sorry, what was that?
Oh, I'm just saying that's scary. It involves our land and water. Yeah, that sounds super sketchy.
Yeah, I just again say, just keep it public. Let us know what's going on. You're the government, but license plate reader amendments. We love license plate readers. And just so you know, license plate readers exist in the state. So this black text is existing law already. So we already have license plate readers authorized. And so this bill, oh, sorry, I shouldn't laugh. I just love the things we do. So this bill was passed, and the first it was, don't worry, we're only using information from the reader pursuant to a warrant. So we had to have a warrant. There was a check and balance still. But now, and you have to understand, from a non-governmental entity. So if a commercial entity or a private party has a license plate reader, they're scanning, your license plate if you come to their parking garage or whatever, the government can now get that without needing a warrant. So this is similar situation to DNA. The government can go to Ancestry and say, hey, will you see if there's a match in your system? Ancestry says sure, and they're checking DNA without warrants, essentially. And this is openly allowing for that to happen. And in addition, it goes on to say that, again, this governmental entity can obtain, receive, or use captured plate data from a non-governmental entity. And it used to be only pursuant to a warrant issued, but they're saying no more warrants anymore, you can just have it. And we want to be able to start to, yeah, just have the information from these other entities. So I think there became, at some point, someone's going, oh, I can't get that info because I have to have a warrant. Well, I want the info. And so we have this bill saying, if you have airport authorities, and I don't know if all airport authorities are considered governmental or not, or inland port, I know uses, they said the inland port uses license plate readers, airport uses license plate readers. I'm trying to remember all the places that I read about that used them. But the government is seeking to get that information without a warrant. So I guess a privacy issue to be aware of with that one. Let's see. Oh, here we go. No, actually, sorry, this isn't the right one. This is talking a little bit more about what they can use it for. And so, you know, the government's not supposed to use captured plate data for a purpose that's not authorized. But they can preserve and disclose aggregate captured plate data, planning statistical purposes, a bunch of things. So we're getting a lot of readers in place, more and more of them. And maybe that helps with safety, maybe it doesn't. But those are some of the things to be aware of with that one. Let's see. This one, I always want to point out if I think that there's a decent bill. I think this one's an okay check and balance. Because one of the things that started happening is that if there's a vacancy in a city, I've seen this in a couple of cities around the nation, where they suddenly go through and pass some laws to make it very, very difficult. So for example, this was actually the state level, it was North or South Carolina. And they're close in their battle between Republican and Democrat control. And there was a Republican Congress the election took place, and then they had a Democrat governor and AG coming in, and they voted in that little bit of time to change the power of the governor and the AG to strip a lot of power from him. And this is something that is meant to try and help protect against some of those games, at least at the city level, where they're saying during this interim vacancy period, the council can't throw a manager in that the mayor has to work with, but they also can't adopt an ordinance. And that was already the law. So they already couldn't put a manager in place. But now they're saying you can't adopt an ordinance that establishes a procedure for the dismissal of a manager that's more restrictive than what's already in place. Meaning we can't force you to keep, a particular city manager. You get to kind of work with your chief of staff, so to speak, as the new mayor. I think this is generally healthy to the political process, is that if you have a new mayor or governor come in, they should be able to select their people under existing procedures, and that shouldn't be played with in that little bit of time between them getting elected and coming into office. Others may feel differently about that. I respect that. But that is the main gist of what this bill's shooting for, and it's HB 109. I don't think I said that at the start. This one, though, is interesting. I did have to laugh a little at this one. So Utah doesn't have a recall election procedure in place. And so this is proposing to let us have recall elections for mayors. And recall elections are very interesting to kind of see how they are, how they're run, or what rights kind of exist under them. So if we scroll down, there's a lot of existing law here, but the recall election part starts to come in here. And some of the things it talks about is that, so it says you can seek the removal of a mayor from office via recall election, and you have to have a recall application. The recall application has to state this, that the signers seek removal of the mayor for the commission of a high crime, a misdemeanor, or malfeasance in office in accordance with Utah Constitution Article 6, Section 19. So you can be removed from office for a high crime, a misdemeanor, or malfeasance in office. Generally, that was supposed to be through the impeachment mechanism. This is extending it to people being able to do that. So that piece means you can't just remove a mayor because you don't like them. You actually have to have that they've committed some type of crime or malfeasance in office. But this is that it gets a little more interesting here, where it says the county clerk that receives this recall application shall, which is mandatory, shall reject a recall application if, and then it says here in number 2, the county attorney determines as a matter of law that the conduct alleged in this petition essentially if true, does not constitute grounds for removal from office under Utah Constitution. So they're saying that if I go and say, well, the mayor increased taxes and I allege that violated the Utah Constitution, the county attorney looks at that and says, no, raising taxes is clearly not a violation of the Constitution, so therefore your recall application is denied. The concern I see with this is that what they're doing right here, this is actually, I believe, an unconstitutional transfer of power. The county attorney doesn't have judicial authority to determine what constitutes what the actual law is. And that's not a authority that's been given to the executive branch. That's the judicial branch. It should be a judge that's separate and distinct, because the county attorney can work closely with the mayor. You know, this isn't the county mayor. This is a city mayor we're talking about. So there is some separation there, but they can still work together quite often. And there's not the independence where it's executive branch supposedly checking executive branch, and the executive branch is making a determination as to what constitutes legal grounds or not. And there's no appeal put in here from this. If the county attorney says, nope, that's not a crime, then you just don't get to do your recall election. But again, on the separation of powers, Utah's actually been pretty strong about the separation of powers side, where when they attempt to give judicial authority to the executive branch, the courts have struck that down. I've been part of a case in Utah. I drafted a brief for the Utah Supreme Court on that, where the courts agreed and said, yeah, we're going to strike this law down because it lets the executive branch make judicial decisions. And so I could see a constitutional issue with this. But just again, as a practical matter, it becomes very political again. And I don't think recall elections should be crazy political, meaning, you know, just because you've fallen out of political favor or whatnot. So I was concerned about that. The other thing that I did laugh at in this, that I don't understand, is that, let's see, I don't remember exactly where it is in here, describes the ballot signature and stuff, but here it is, signatures required. They said that they will hold a recall election if the people, you know, trying to get the recall can submit valid signatures of registered voters who reside in the municipality equal to 50% of the number of registered voters who voted in the race for mayor, at which the mayor was last elected. I don't know why we're holding an election at this point. If you have 50% of people already that sign a packet, I don't know what the point of the election is. Curious if you have thoughts on that, Jill.
Yeah, am I unmuted?
Yeah.
I just find it interesting that the ULCT is opposing this bill.
And who is
So-
the USCT?
Oh, the Utah League of Cities and Towns.
Oh,
That
okay.
is, that's the mayor's group. So I
Gotcha.
just thought that was interesting.
Yeah, and I think they would oppose it because of, again, being subject to recall is not super fun. But the mechanism in it, where the county attorney has judicial power, and then you have to get 50% of the vote to hold an election. Again, I don't fully follow that logic to say, why is that the case? Because again, why hold the election at that point? 50% of registered voters say, yeah, we want this person out. So unique. I don't know where this one will go. I don't know if it's a bill that has strong support or not. I don't know if it's Utah's way to say we're going to, you know, make you feel like we're moving in the direction of recall elections, but we're really not, because the chance of getting 50% of signatures and of the county attorney agreeing are so low that it won't really do anything. I don't know on that, but that's one to be aware of. This one we can talk about quickly voting precinct amendments, HB 27. Normally, the county clerk, normally let's see, the county legislative body changes boundaries of a voting precinct. And so if that's the county council or whoever that is, and again, that I think is appropriate where it's going through the legislative process. But this is authorizing the county clerk to adjust precincts that are 3,000 people or less without input from the legislative body of the county. I don't know, again, on background what gave rise to this, but from a checks and balance perspective, I'm never a fan of consolidating power. I'm sure it makes things a little more efficient. I'm sure it makes things move faster, but I don't love that a clerk can just go out and change voting precincts on their own without a check and balance. So that's the main thing there. Let's see. Oh, this one came in like HB 69. This is in response to, I don't know if you saw the news about the Utah County Clerk, and he posted publicly that, I think he said Senator McKell, but he said one of the reps or senators didn't put postage on his return envelope for his ballot. And he went in and looked at that and then made that public. It wasn't illegal for him to do that or say that at the time, but they were very upset about that. And so this amendment is intended to make it, so they have this voting history record. This is information related to a registered voter, and they're going through to make it more private so that you can't publicly disclose these things. And they specifically say you can't publicly disclose the method by which a voter returned a mailed ballot, or whether the voter paid postage on a ballot returned by mail. So very direct, targeted response to a situation. Sometimes that's appropriate, but it is, I don't know, it's one where I personally think in general, there's some level of, we do need some level of privacy in voting, but we also need that balanced with appropriate checks and balances and accountability and oversight in voting as well. And when we just have kind of a shoot back type response, just a quick off the cuff response, I don't know that's always thought through or principled. It's more just responding to a situation. But they go through these things and, you know, they talk about government information, not releasing that. So the government officer, due to their position, can't go through and just get information and release it. So again, I think there's some good things with this principle-wise, where we do need some of these protections. And I didn't see anything. This was a very targeted bill. I'm sure there's some consequences of it. I haven't fully thought through with it. But we're amending the GRAMA Act to make information more restrictive. So again, just in general, I get wary about that.
Hey, Austin, I got an email this morning from Vince Newmeyer. I don't know if you know him. He's really involved in election integrity, and but yeah, he mentioned some of that, like line 65 through 69 creates a new class of protected records. That was concerning. And then also he said line 93 through 98 eliminates the public. So he said the bill like flips almost completely the election records that were considered a public record to be a protected records. So eliminating almost all transparency. So yeah, anyway, he was super concerned about this bill also.
Yeah, so this one here, you're talking about notwithstanding the time limits for response to a request for records under this section, the election officer shall ensure that the information required to be disclosed under this section is recorded and made available no later than 1 business day after the day on which the election officer receives the information. And so, yeah, this one's interesting in that in some ways it could actually broaden the requirement of disclosure than it was before. This is saying it has to be made available. And when they take out to the public, it could mean that they're saying you don't have to make it to the public, depending on what's happening, but they could also be saying you have to make it available to whoever you're mandated to provide it to, whether that's the public or an election officer or whoever. Because before this bill would only apply to information that had to be made public, but now a court could construe it as applying to information that stays private but has to be disclosed to certain officers or to the public. But I wouldn't be able to comment on that without really dissecting more of all the records and who they're being reported to, and if there's other provisions that require that they be made available to the public. But my bet is that there are some things that restrict grandma further than we're intending. You know, it's more than just the method by which a voter returned a mailed ballot or whether they paid postage. There's some other things happening for sure. But it's not all here. It's referencing other sections. And so we'd have to go through and dig through some of those to fully understand it. And just with my time before this call, I was not able to follow that one all the way through. This one, I'd be surprised if this one passes. But I think this is a good one. So we had the government pass some constitutional amendments this last time around, and they said, and the legislature chose to draft their own summary for the Utahns about what was in the bill or in the amendments.
Pull back up. I'm super sorry.
Yeah, what's the number on it?
Yeah.
Sorry, it's fine. I
Sorry.
forget to do that. HB 101.
Okay, thanks.
And the legislature, it used to be that they had this independent group prepare their summaries for these things. But then they took it over and they said, no, we want to prepare our own summaries. And it was very political. They were very slanted summaries, very intending to try and get people to do certain things. And so they got sued over it. And there were 2 lawsuits. And in both lawsuits, the courts agreed. They said, yeah, these summaries are so bad. They're almost like a fraud. They don't accurately describe to the voter what's taking place. We're just going to strike these amendments as void. You can't run it with these, with how bad these are. And so Representative Romero is proposing, oh, yeah, that makes sense. Why don't we go back to just have the Office of Legislative Research and General Counsel? They're impartial. They don't get into politics. They can just prepare an impartial ballot title. Let's pull it out of the political spectrum and just let some attorneys just draft a summary of it that's impartial. And so that's our proposal. And I'm a big fan of that. I personally believe very strongly anything on the ballot should be very accurately described. It shouldn't be political at all. So this is a bill I do support because it's making it so that the legislature doesn't get to draft its own. Because before, what they had changed it to, it used to be, or it still is currently, if this bill doesn't pass, the presiding officers of the Senate and House get to draft a summary. And I go, yeah, let's put it with the Office of Legislative Research and General Counsel. Big fan of that. So that is one I support. But we're at our hour today. And so again, if you have things you want to talk about specifically or follow, let me know. We'll go through some of those, and then we'll just pick back up next week with some of these bills we didn't get to. And there'll be plenty more proposed next week. Like you say, there's a lot coming out. If it makes you feel any better, which it probably doesn't, there's not as many bills this year as there have been in, I think, the last year or two. So they've toned it down slightly. So we're not at a record year for bills proposed. But again, the invite is there's too many to focus on everything. So pick 1 or 2 that matters to you and then reach out to your reps on it, follow that, try and trace it through. It's good to be in the know, to be able to talk to others, but don't take on the personal responsibility of trying to defeat or make sure everything wins that you want. It's too big a task, and you have to manage life and all that too. So be involved. Don't overdo it, and just let me know, and then again we'll talk next Tuesday and go through this more. So thanks to those that joined today. Appreciate you being here.
Thanks, Austin. Does anyone know? I know where to go on le.gov and get a list of bills that are up this session, and I know you can click on them separately